Yeah, thank you. Thank you so much for. Oh, you need a chair. You need a chair. Yeah, but probably yeah. So we can rotate a little bit. Yeah, thank you so much. We have to. Yeah, we have to start. So without long introduction, I wanted only to say. So thank you very much for giving me this opportunity to chair this first session after introduction. And I would like only to stress, we had yesterday also a number of discussions concerning the impact of crisis of judicial power, of independence of judiciary, and crisis of institutions. Pardon me? Yeah, I think so. Does it work? No? So sorry, maybe this, yeah? Can you hear me now? Okay. So we have discussed yesterday in the dinner and different settings the relevance of what is happening with institutions of judiciary and its impact of the current political situation, with deterioration of democratic institutions, which is happening to some countries, and my country was one of example, which is Poland, named today. And in our association, the name of our association is International Association for Independence of Judiciary and the World Peace. As I entered this association, I was asking myself whether it is absolutely self-convincing that there is this connection between independence of judiciary, which is kind of tool, and the peace in the world. And now we can see we are in this dangerous international situation. The war is in many places, but this process of deconstruction of institutions has impact. It's somehow linked to what is happening on the political scene and what is happening to our democracies. Therefore, we have extremely important topic we were discussing yesterday, and our first speaker, I just give the floor immediately to Professor Marieta Safta from the Maiorescu University in Romania. But just we are analyzing what is happening to Poland and to Romania, and the picture is quite different. But when we are asking ourselves what is in common and what is the origin of this deterioration, of this process which we are experiencing, and what will be the outcome, and why the Central Eastern Europe was particularly affected, but not only. So we are starting with Professor Marieta Safta. You have a floor. We have to stick to the time limits because we are in delay, so 10 minutes for your speech. Thank you so much.
Thank you very much. Good morning, everyone. Okay. Yeah. Okay. Esteemed President, esteemed organizers, dear professor, colleagues, dear students, it is a pleasure and an honor for me to be here today. Thank you very much for inviting me. It's my first time here in your university and my first time in Cyprus. And I would like to thank you for your hospitality and to congratulate you for organizing this amazing event. Today, under the title Undermining Judicial Independence Through Policy and Perception, the Romanian Experience in European Context, I have chosen to address a topic that has moved to the centers of the public debates in Romania these days. The ongoing dispute over magistrates' pensions in Romania shows how political discourse influencing public opinion can weaken magistrate status and judicial independence with effects that becomes a matter of general interest, extending outside the country's border. The debate on the service pensions has evolved for beyond financial consideration. It has become a conversation about the role and the legitimacy of the judges in the society. Increasingly, politicians and describe magistrates as privileged groups, assigning them the responsibility for the state's financial imbalance. I have chosen to examine this issue in the context of the conference's broader theme on the challenges of implementing European standards, among others, the Mount Scopus standards, which all emphasize that material guarantees are an essential component of judicial independence. Just in a minute to understand the debate, the specific debate in Romania, I will clarify the meaning of the magistrate. What does it mean, magistrate, according to the Romanian legislation? According to the Constitution, the term magistrate refers to judges and prosecutors. However, in the context of examining service pensions, where the legislation in the field of justice operates with various assimilations, we identify a sui generis concept of magistracy provided by the law and also the case law of the Constitutional Court, which includes several categories of staff. Judges, prosecutors, judges of the Constitutional Court, assistant magistrate of the High Court of Cassation and Justice and Constitutional Court, and specialized legal staff assimilated to magistrates. We can say that the constitutional and the legal distinctions reflects a layered view of judicial independence. In this view, only judges fully embody the constitutional and European guarantees of independence, while the other categories are structurally integrated into the system with complementary roles in the functioning of the judicial authority and constitutional review. The Mount Scopus standards and other European Union and international documents emphasize that judges must benefit from appropriate, stable, and protected remuneration, including pensions, precisely because financial security shields them from external pressures and dependency. These material guarantees are not ornamental. They form part of the structural framework that enable judges to adjudicate impartially, confidently, and free from fears of retaliations. Starting in the early 90s, after the Romanian revolutions, Romanian judiciary was shaped by successive waves of reform, gradually adopting a constitutional and legal framework that aligns with these principles. The first post-transition statute in 1992, and after that amended in 1997, established the service pension, granting magistrates with at least 25 years of service the right to a pension amounting 80% of their salary. This system, created through a political decision, was intended to attract qualified legal professionals into the magistracy. The 2004 reform package brought modernization and alignment with European standards in the context of the Romanian steps prepared the accession to the European Union. It consolidated the structure of the judicial careers and preserved the philosophy that material safeguards, including pensions, are integral to the independence. However, this regulation, based on the idea that the service pension is a guarantee of independence, not a social privilege, has become step by step a source of tension in public debate, with the judiciary often turning into a favorite target for politician and populist rhetoric. In 2010, the attempt to transform the service pension into a contributory pension, assumed by the government, was found unconstitutional by the Constitutional Court. In 2020, the government came up with a new radical solution, this time for all service pensions, but without any analysis or regulation of the statute of the targeted staff categories. It was a general promise that in 6 months we'll have a new status in these regards. This regulation was found unconstitutional by the Constitutional Court. We should emphasize that the Constitutional Court developed an extensive and consistent jurisprudence according to which the service pension is a constitutional guarantee of judicial independence, that it compensates for constitutional restrictions such incompatibilities, prohibitions, inability to engage in other income-generating activities, and that only those who build an actual judicial career may benefit from it in order to preserve the integrity of the concept of magistracy. Meanwhile, the public debates around the topic have become more acute. Three key aspects of regulation of magistrate pensions can be followed like a seismograph would say. First and foremost, the amount of the pension, including by reference to its base of calculation, the retirement age, the length of service in magistracy. Regarding the amount, both the percentage, 80%, especially the base of calculation by referring to the gross income and not the net one, determined for certain periods that the pension establishing payment was higher than the last net salary of the retired pensions. The retirement age, around 50 years old, has also been criticized compared with the standard retirement age of 65 years old. It is also important to notice that the legislator did not intervene promptly and targeted manner to correct certain provisions, such as those arising for calculation of the pensions, but it instead opted to introduce so-called radical reforms in 2010 and 2020 aimed at the complete elimination of service pensions or their transformation into contributory pensions. In 2022, a new legislative package came, and this legislation was amended in 2023, so that starting with 1st of January 2024, both the seniority requirements for the pension payment, the retirement age, and the base of calculation for the service pension were changed. Likewise, the pension was limited, meaning that the net amount of the service pension cannot exceed 100% of the net income earned in the last month of activity before the retirement date. However, the new rules included transitional derogations, failed to stop the ongoing criticism of magistrate service pensions, their statute in terms of benefits, which continued and escalated amid government austerity crisis claims and reference to European obligations in terms of the fulfillment of the European Union milestone to obtain funding. As a result, new amendments were introduced to bring service pensions closer to contributory schemes, and the most recent law was declared unconstitutional on procedural grounds. A new amendment has now also been adopted, and it was being challenged before the Constitutional Court. Yesterday, the Constitutional Court postponed the term for the decisions on 28th of December. Consequences to this legislative instability, there was added a political and social rhetoric that turned the issue into a much broader public debate concerning the statute of the judges in the society. The discussion shifted from the institutional reform of the pensions to talk of privileges, where magistrates, including judges, were no longer viewed as guarantors of rights, but as beneficiaries of undue advantages. As a result, material guarantees, which are internationally recognized as safeguards of independence, came to be seen by the public as sources of unfairness. More recently, the situation has escalated into direct threats, indictments of violence against judges, even in courtroom, and proliferation of hate speech. Such developments reflect not merely dissatisfaction, but a deeper delegitimization of the judicial function. In parallel within the system, the atmosphere has become one of uncertainty and demotivation. The consequences are visible. Recent reports from Superior Council of Magistracy show sharp increases in retirement requests and the systemic paralysis, particularly at the higher levels of jurisdiction. The current crisis is therefore not simply about the pension system, it is a crisis of stability, predictability, and social legitimacy. And concluding, we can say that it's a discussion about the specific issues of the legislative system of Romania. But I think this experience, it's important and interesting to debate in this framework because it highlights a dual challenge: normative alignment with European principles of independence and societal acceptance of the material and institutional implications of those principles. From the perspective of the challenges involving in implementing the European Union and MAUT Scopus standards, a persistent tension emerges when examining the principle of judicial independence, standard 10, appropriate and protected remuneration in the context where judges are increasingly perceived as privileged group whose financial and other benefits, because now we discuss about salaries and other benefits, exceed what society considers justified. This raises fundamental questions for all of us. To what extent can the judiciary maintain its legitimacy and independence when public opinion views judicial remuneration not as a safeguard of impartiality, but as undue privilege? And one word, I think that strength of judicial independence depends not only on legal safeguard, but also on societal understanding and acceptance. And looking forward, the discussion should shift toward establishing, I think, a coherent European level statute for magistrates, ensuring predictability and uniform standards, and exploring mechanisms such professional insurance system for judges and prosecutors, measures that both protect independence and reduce public suspicion. The trust we discussed from the beginning of this meeting. Thank you so much for your attention.
Thank you so much for this very important question, which we have. We have also discussed it for a long time in our Mons Scopus ELI rules on question of retirement. It's another quite interesting issue of this early retirement rule. I met in Ukraine, for example, very young retired judges, and this is quite interesting question. What kind of impact does it have on judiciary? And we can discuss it later on. But now we are inviting the second speaker, Professor Graham Zulik from London University, about the secret state and judicial independence. So you have the floor. Thank you so much. Zulik.
Good morning. I should perhaps declare that I am in receipt of a judicial pension, but I believe in keeping my options open because I also have a university pension and a public service pension just in case. Now, I read in this morning's Times of London that today is Judicial Wellbeing Day for judges in England and Wales. And the judges are asked to consider small acts to support their well-being, from taking a mindful moment to going for a walk or joining colleagues for a well-being activity, including an exercise session in the main hall of the Royal Courts of Justice. I prefer being here with you to doing an exercise session in the Royal Courts of Justice with my fellow judges. The last time I spoke in this area of the law, my title was License to Kill. Are those who work for MI5 and MI6 empowered to commit crimes? Now, my topic this morning is a little less exciting than that, as befits the time of day, but I hope no less important. My interest in all of this stems from 10 years' service as a judge on the Investigatory Powers Tribunal, the UK court that is devoted to dealing with actions against the intelligence services. The full title of my topic, which is covered in the full paper if anyone's interested in seeing it, is Does a Judicial Role in Regulating the Security Services Compromise the Independence of the Judiciary? And I want to flag one particular thought which I hope you'll keep with you during the course of the day. And that is, don't discount the possibility that judges themselves, by their decisions, may damage the independence of the judiciary. The principal challenge arising from the existence of secret intelligence services in a state has long been recognized. How do you exercise effective oversight and regulation so as to ensure that they operate within the law and in the public interest, to defend democracy and national security and not to undermine them. My subject today goes to the next stage. If judges are assigned a role in this oversight role and regulation, as I believe they should, does it pose a threat to judicial independence? And if it does, can it be avoided? Now, there are two preconditions before one gets into this area. The first is that the intelligence services themselves must be recognized and established by law. A secret service that just exists privately at the behest of government is not going to be subject to a proper system of oversight and regulation. And secondly, having established organizations like the FBI, the CIA, MI5, MI6, their powers have to be specified in legislation with clarity. Now, there are two functions in relation to the regulation and supervision of these agencies that are intrinsically judicial. One is the granting or authorizing of warrants to engage in intrusive covert activities, telephone tapping, computer hacking, planting microbes in houses and in cars, surveillance, use of informants and so forth, accessing data communications. And the other judicial role is to adjudicate on complaints that the agencies have acted unlawfully. You might think this should be straightforward, but it isn't, and it poses severe challenges to the independence, and perhaps even more important, the perceived independence of the judiciary. How then can judicial control be reconciled with judicial independence? That's the dilemma. It's essential to involve ordinary members of the judiciary, but no less essential to find a way of doing so that is compatible with the independence of the judiciary. And this is not something that's specifically addressed in the Mount Scopus standards or others, and not surprisingly, perhaps. Now, in this brief presentation, I can't do more than just set out the general considerations that should govern the situation. As I say, for those interested in the UK detail, it's all set out in my longer paper. Now, the two judicial roles that I've identified, issuing warrants, adjudicating on complaints, could be vested in a single body. But that would be objectionable because the court adjudicating on complaints will often have to consider and rule on the legality of the warrant or authorization. So they should be vested in different groups or different bodies. The next question is whether individuals alleging unlawful action should have to bring their claims in the ordinary courts, or whether there is a case for a bespoke court with specially designed powers and procedures. Now, my preference is very much for the latter, because these cases present special characteristics which require discrete powers and procedures, though I emphatically mean an authentic judicial body and not some administrative entity masquerading as a court. However, the creation of a specialized court, like my Investigatory Powers Tribunal, inevitably arouses suspicions and thereby poses dangers to the perception of independence and integrity. It's important to understand why exercising a role in relation to the security services presents particular difficulties for judges. It's obvious, really. It arises from the secret nature of the operations of the security services. In order to preserve that secrecy, as regards their lawful activities, and that's essential to national security, much of the work of any judicial body in this area must also take place in secret, away from the press, the public, and even the alleged victims and their lawyers. Secret courts and closed judgments are the very antithesis of the judicial process in countries based on the rule of law. Such a lack of transparency can lead to distrust, to accusations of bias and lack of independence, and allows inferences to be drawn that the judges and the courts are nothing more than a fig leaf protecting government agencies and indeed the government itself. Not only would such views discredit the machinery devised for the purpose, but even more seriously endanger the reputation of the whole judiciary in standing fearlessly between the citizen and the state. Accusations of secret courts damage confidence in the process, imply that judges have been willingly conscripted to whitewash the intelligence agencies. But by being alive to these risks, it is possible to a very large extent to avoid them and respect constitutional proprieties. I suggest that the following are the basic design features of a system for judicial involvement in the intelligence service if judicial independence is to be safeguarded. First, establish a corps of possibly retired senior judges to authorize the warrants necessary for the more serious intrusive investigative powers. They must, as I have explained, be separate from the court or tribunal that may in due course have to rule on whether a warrant or authorization was lawful. The appointment of these judges or retired judges must be immune to government interference. Secondly, provision must be made for the adjudication of claims that the security services, and indeed any other public authorities with comparable powers, and there are a number, have acted unlawfully, and to provide effective redress to victims. But should this be a wholly specialized court, a specialized chamber within an existing court, or simply a new jurisdiction within an existing court? The case for a specialized court, but fully part of the justice system, is that it requires special powers and expertise which are not a natural fit for an ordinary court in an adversarial system. The case against is that it fuels the belief that complainants are being offered second-class secret justice and denied access to the ordinary courts. The aim must be to provide a forum that is recognizably a proper court and as close to normal due process as possible. Now, I'm going to have to draw to a close there before I can set out for your pleasure the 12 points that would establish such a separate court in accordance with constitutional proprieties. But as I say, I believe it can be done. I believe the Investigatory Powers Tribunal in the UK has come pretty close to doing it in a successful way, though it doesn't meet all the criteria I've set out. And I do think, though this is perhaps a very small part of judicial independence in protecting democracy, it's not one to be ignored. Thank you very much.
Thank you so much for so important analysis. And once unfortunately, Polish experience shows how important it was. It was in relation with the system called Pegasus, with the Israeli origin, unfortunately, which has been used in Poland against the opposition, and with the authorization of the courts, even they were not able to verify how deep the system goes into the system, and it has undermined the reliance into the judicial control extremely, and therefore this is an extremely important topic. Now we are going again, Eastern Europe will play a role in Central Europe in our debates as battlefield of the judicial independence. Professor Alexander Trunk, you have a floor.
Can I use it here? I try. Okay. Today with tablets, life has changed. Well, thank you very much first for giving me the possibility to talk, and thank you also to the organizers for having this wonderful conference. My talk today will be a little bit of a comparative thing. It's about judicial independence in Eastern Europe. And I will separate that into two parts. So more general remarks, maybe even questions, and then some examples, because one cannot compare everything at the same time in a systematic way. That's not possible. So I've seen that several of the speakers have a comparative focus in their speeches, also in their research. And when we did the ELI Mount Scopus principles or standards, we always had, let's say, discussions from different experiences. That is a kind of living comparison. But the standards themselves are, of course, not comparative. They are a result. But they have to be tested in reality, and they have to, that has to be, it makes sense to do that also on a comparative basis to see whether one can learn from some examples in other jurisdictions. My focus will be here on Eastern Europe. And the question is, of course, why Eastern Europe? Of course, Eastern Europe is not everything, although Eastern Europe is large in the sense which we lawyers are accustomed to use. But one can, of course, look at other regions of the world. One can group countries in different manners. One can group EU member countries, states. One can group countries, member states of the Council of Europe, or maybe within Eastern Europe, certain groups, subgroups. That is all possible. Everything depends on where we can learn what and how we can transfer what kind of information we get to other countries. Because I think that was mentioned already today in Professor Chitrit's speech, that we have certain general developments, general global developments, challenges. That is, of course, based on a kind of evaluation and watching what happens in different countries of the world. And also Eastern Europe is one of these regions. I've chosen that because I think Eastern Europe is a kind of laboratory for many aspects. And it has some common ground. I must say it's maybe a thesis. One can dispute because one can always look at the specific case and say, okay, it's completely different from others, but one can also say, okay, there are maybe some similarities, and what can we learn from that? Comparison sometimes, for me at least, makes sense when you compare very different systems, but also it makes sense when you compare different systems which are linked, which have some common background. Because then, for example, when you look for countries in the territory of former Yugoslavia, you see a lot of discussions happening there and there and there. We have here some presentations from this region. And what I learned from my own research is that it is very common in between these countries to look at what happens in other countries. And then that can go beyond that. We mentioned today, or it was mentioned, Poland and Hungary as examples, countries which are Central European countries, but nevertheless, they have certain phenomena, different, but at the same time, based on a certain common, maybe, background. So, by the way, Eastern Europe, just to make it clear from what is my starting point, is not limited to Europe in the geographical sense. I would include also Caucasus. I have learned that even Cyprus is geographically not Europe, maybe it's Asia, I don't know. Maybe you see it differently, I don't know. In any case, culturally, politically, it's Europe. So the term Europe is not necessarily limited to, let's say, the borderline of some geographic, let's say, definition. We also include, or tend to include Central Asia, which is apparently not Europe, because it was just formerly a part of the European Union. And there are some commonalities, and Kazakhstan, by the way, has a part of Europe, like Turkey has a part of Europe. It's at the same time, Asia. So again, it just shows that the term is quite large. Now, when we look at countries of such a large space, and that again doesn't exclude looking at other countries as well, we can ask for similarities, commonalities, and different, let's say, specifics. And the typical way of looking at Eastern Europe is at looking at the history. Of course, the history is history. It means that at some time it is, let's say, it gets into a kind of farther background. And the history in this category is normally seen in the socialist past. Now, socialist past is already only a kind of small part of the history and has deeper roots. So when you look at, for example, Russia, you can also look at Tsarist Russia. When you look at Ukraine, you can look at farther past. Nevertheless, the socialist past, some often talk about post-socialist situation, but post means always, well, when is the post no longer post, when it's new. But in any case, this socialist past can be seen as a kind of common denominator, and that's a thesis. Maybe you will argue against that. And what do I mean by common denominator from historic point? We say that, for example, we had in the socialist time a communist or socialist party, which basically dominated the whole game and was in principle unrestrained. Members of the party thought themselves as a kind of elite, which should not be constrained by anybody. At the same time, they had an element of ethos. I wouldn't deny that. But at the same time, when you have no boundaries, no limits, you create chances and possibilities for misuse. And this plays a role when we look at these countries. I think when one looks at these countries today, because when we have the tradition of a group of people who think they are higher than others, they know more, they are elitist, they don't need control. That can, of course, play an eminent role when you look at judicial independence. Because when we talk today about developments in Poland or in Hungary, where sometimes it's called autocracy or whatever, it means that there is a tradition of thinking saying that why should judges control us? We are the government, we know what is better. So it's not only Mr. Orban or whoever, but it's also a kind of deeper root, I would say, which one finds in several of those countries. We see several countries which, even if they call themselves democracies in the constitutions always, they are not real democracies. I would say, I don't name here names, but there are many countries which have a formal, wonderful judicial independence guarantee in constitutions, but they are governed by a small group, even some person, individual, in some way. So one always has to look beyond the mere text of the law, of the laws. One has to look at reality, at practice. And what is interesting that out of these communist or socialist past come groups of people who have completely no values, who will use nihilism, who use profit, money to have influence. Maybe that also comes to a certain degree from this unrestrained power of the former times. Maybe that can change also, but it's a kind of common thing which I find surprising when I watch it. Of course, we have at the same time diversities. We have national backgrounds, we have cultural backgrounds, we have good and bad leaders. Sometimes we have an international framework. Some country is a member of the EU, another country is a member of the Council of Europe, another country is not never been a member of the Council of Europe. There are different reasons of all that. And but nevertheless, going beyond this mere specific case of problem, we can sometimes find a pattern, or at least try to find a pattern, because that will help us. I will now just also for the, I see, okay, 1 minute left, wonderful. I will just mention that when we want to come to a result, we need not only look at individual cases, we also have to find some, let's say, measures to evaluate where are we at the moment with judicial independence today, where should we go, how should we develop it, and that comes back to the issue of measuring. I think that is an issue which one should have in mind, how to measure judicial independence. We have different rankings, we have different reports, EU scoreboards and so on. They are all good, but they are, when one looks at them in detail, I would say they need to be used, but one should not limit oneself to that. One should watch at specific cases. So the measuring is an important thing, also for the development of future tools. And now I come to the more specific examples. It's a little bit funny, maybe not funny, but more instructive, because that what I said today was general. The end will be, let's say, the more specific case. I choose some countries, maybe just for a small word: Estonia, Poland, Hungary, so Central Europe or Northern Central Europe. Then Russia, Ukraine, Eastern Europe in the strict sense, in the Caucasus, Georgia, and Central Asia, Kazakhstan. One word: Estonia is the model success. Is it? Second, Poland, element of, let's say, judicial independence as the consequence or as an object of political infight, so political pressure upon the judiciary. That was this issue, and the question, of course, which we'll have, how then can that be overcome? So it's the political side, political pressure on the judiciary. Hungary, we have there a strong focus on corruption issues, also from the side of the EU. The question is, of course, always, and sometimes, which one asks, whether this focus on corruption has something to do with the political position of Hungary. Hungary being non-conformist in certain matters, is that the reason why corruption is a topic? So one should ask and can ask. And then I finish Georgia, a country where I was recently. It's an issue of big discussion today, also for international reasons. But one element is the pressure on the questions from within. There has been criticism that from within the judiciary, you have groups of judges, elder judges, who try to determine everything. It's the kind of issue which came up also. So it's not only the outside pressure, but also the inside structure. One can call that a kind of historical, Soviet, whatever, post-Soviet past. How can one overcome that? Well, thank you.
Thank you, Alexander, very much for this very interesting comparative analysis of the region. And even I'm coming from this region, it's quite difficult also. This is a matter probably for great discussion. How far more than 30 years after the transition, this communist reality or post-communist reality still works, and to which extent, and what is actually the really deeper in the structure of the states, and it's not only a result of a transition period. It's a very important, interesting comparative question. Now we are going to Italy. Professor Daniela Piana, we are delighted that we have you here online, and unfortunately you are not with us here in person. And you will speak about another fascinating topic, courts and memory. So you have a floor. Thank you.
Thank you, Mr. Chairman. Thank you to all the organizers to have me as a panelist in such an inspiring and important space of debate. My talk today is basically based on a previous empirical research made also, but not only, on particularly dramatic cases that have been treated in courts in Italy related to terrorism and dramatic events that, marked the history of the country. But the purpose of my talk is not to talk about Italy. Italy is just, a case as an heuristic, if you want. My idea is to share with you some insights and some remarks in order to suggest some integration or points that can be added to our list of standards in the field of judicial independence protection. I'm going to share my screen now, if I'm allowed to do so. Apparently, I'm not allowed to share the screen. If the organizers can put me as an organizer or co-organizer, or otherwise you have my PowerPoint presentation. Thank you.
It works already.
Thank you so much. Let me just make it a little bit better on the screen for you. So, courts and memory, dramatic events, and radical conflict. Let me start from someone who was quite important in setting the debate about justice, justice and memory. A few decades ago, Paul Ricoeur, in his seminal work Le Just, wrote a short-term purpose is among the two purposes of courts and judging, which is a short-term, settle the conflict, settle a dispute, and so reduce the uncertainty between two litigants. But there is also another important purpose which is in the hands of courts and judges, which is the fact that by, delivering justice and meeting the demand to justice, they basically contribute to social peace. And I think that this double time frame that is featured by justice systems in the way they function has become particularly important nowadays. As a matter of fact, this is an everlasting subject. When you have a dispute, the first thing that is important for the litigants is to settle the dispute in a way that is perceived as fair, acceptable, and also based on an impartial and impersonal method to settle the dispute. That's the reason, the fundamental reason we have courts. But there is something more. There is also the fact that in the way courts function, they refuel, they restore, they reaffirm the importance of the rule of law, and they contribute to mitigate where there are conflicts. So this is the reason social peace is so important. And we cannot start in our reasoning from the premise that all the litigants and all the community that is observing the trial as it unfolds alongside the time frame, all these people share in principle the same values. This is something that cannot be taken for granted. And especially today, it happens often that this is absolutely not the case. What's new in particular? Well, what we observe empirically speaking in the countries, in the world, is that we have harsher conflict within political systems, also in so-called advanced democracies. And these conflicts are in part, not always, but are partly related to cleavages that do not, address different preferences. So, the classical social cleavage that you have in a democracy, and this is part of the game. But we have more and more situations in which the cleavage is whether or not the rule of law is acceptable, whether or not we want it to be a community. So the cleavage is very deep. And on the top of that, we have conflicts that are going across national borders, not only because the litigants are states, are governments, but also because the litigants are moving across national borders. And if we combine this empirical fact with the Paul Ricoeur, remark, having in mind that you have the trial today, but the impact of this trial is something that may be reflected also in the long term, then this, mobility of people across states, across regions, across societies and legal system is something that we should take into consideration, and not as a, something theoretical, but simply because it is empirically testified each day. On the top of that, the contemporary age is suffering enormously the challenge that is launched by the digital transformation and the artificial intelligence, combined with the social media and the platform to the rule of law as it is embedded on the structure of the state, because that's what we have in mind from the organizational point of view of our institutions. So let me share with you just two, figure. This is the 25 report published by Freedom House on freedoms, right? So it is interesting to see to what extent not free and partly free countries are spread all over. And in many cases, they are also the location where you have harsh conflicts, but not exclusively these locations. You may have people that are moving across borders. So I will come to, one consequence from this. So let me share with you the other, graph, which is again from the 25 report from Freedom House. This has been published on Freedom on the Net. And we do not have data covering the entire globe, but nonetheless, this is something very important. As you see, not free, partly free, is something that we can observe in many regions, quite, expanded, geographically speaking, and also crowded in terms of population. Observe Brazil, you see, Russia, China, India, so locations in which you have many people. Of course, social media do have an impact in the very short run, because the Twitter, the Instagram, Facebook, and whatever you may have as a narrative based on social media on a trial is something that is immediately impacting on the way people are perceiving what happens in the trial. Why is this so important? This is so important because what we have today is a sort of a paradox, we have the coverage of trials that most of the time are, focusing on dramatic events, or courts are expected to judge on very harsh conflicts, going as far as, touching deep values, cleavages. But at the same time, the justice needs scaled up beyond the space covered by the rules of the state, which might be also good news. But the point is that if things are as we are now describing them, then we need to strengthen and to adjust, as a consequence, our guarantees and protections of judicial independence. Why? Because this notion of judicial independence should be thought with a reference to two times. One time is the present time, and the other time is the type of memory of the way the dispute is settled. And this memory is a sort of a treasury that we put in the hands of the next generations. And on this, sort of a patrimoine, as an heritage, there is not only the action, the word of the law, it's not only what courts do that matters. It's not only what judges are doing that matters, but also the way this is covered by media, this is a narrate. This enters in a storytelling about the trial. And I think that in this respect, the combination of justice needs that go much beyond more and more national borders, combined with the increasing expectation of courts answering and intervening in settling disputes that otherwise will be left, just as harsh conflicts. In the era of digital transformation, digital power, and artificial intelligence, especially as generative artificial intelligence, this combination of ingredients requires from us a very strong action to strengthen the independence in a way that is appropriate and not only based on state-centered, guarantees.
Daniela, we have to come to the end very slowly.
I will. That's my point. And basically, these are the suggestions that I have. I think that we need to include in our actions the obligation or the moral suasion to raise awareness about the media impact potential on memory and future memory when they speak about trials. This is something that should be done. Should be done formally, but also through training for judges and also media. I think that we should introduce specific guarantees of judicial independence, in relationship to the memory in the future. And finally, I think that we should include for fragile states specific conditions to strengthen the actions that judges may do across borders through judicial network, because this may help them to build a culture that is not captured by the state-centric situation. Thank you very much.
Thank you, Professor Piana, very much for this extremely important view and the problem what we have. The courts are also mechanisms to establish facts in procedure, And we have the world where the media, social media, are not really based very often in the public discourse on facts. And this clash, this tension, creates incredible challenges. So it will be a very interesting matter for discussion. But we have to go further. So now Professor Matthias Storme from Belgium, you have the floor. We had always very interesting discussion with Matthias about the idea of judicial independence and also about our Mons Scopus standards. So I'm waiting for your speech. Thank you.
Thank you, Frederick. Thank you to the organizers for inviting me, despite knowing in advance that I will contradict some of them. And I would especially thank Professor Chetrit, knowing that we will have some fundamental difference of opinion, and give him a tribute and my respect for all you have done, not only because you were a good friend of my father and you have defended each other several times, but for all you have done for the rule of law. Nevertheless, the general title is Judicial Independence Under Threat. And I would like to discuss just one of the aspects, one of the elements why judicial independence is under threat. And there are many reasons why there is a populist threat to judicial independence in many of our states, and evidently my experience is not that one of Eastern Europe, so my examples and my state of mind will be more like a Western European state of mind, sorry for that. I name some of those that I will not discuss today. Delay is a very important reason for distrust in the judiciary. Non-performance, complexity of the law, too much demand, and I fear that my colleague Piana is adding even more demands to the judiciary than which they can fulfill. Also incoherence of case law, which is intrinsically linked to the individual independence of judges. So it is very difficult to combine these two things. But also, one of the reasons for the distrust and populist rise against judicial independence has to do with the contents of certain decisions, especially of Supreme Courts and international courts, and with the exercise of power which is inherent in that, or overreach, maybe. So the conflict between rule of law, democracy, and human rights. And as a comparative lawyer, I always go back to, let's say, what I believe are the functions. And in a certain sense, judicial independence and separation of powers are modern inventions. They are a new form for an old idea, the idea of rule of law. The idea of rule of law is evidently 2,500 years old. Just read Aristotle. We always go back to Aristotle and to the Greeks if we want to know what is fundamental. So the idea is very old, but the judicial independence is a modern answer to that, because there was no separation of powers before the French Revolution, let's say, or at least before the 17th, 18th century. There were a lot of treatises and ideas in philosophy about what a good ruler should do, but a good ruler was also the judge. There was a unity between political and judicial power to a large extent. Even if you have very old examples of separating them, in Roman law you had the praetor, who was a politician, who made the law, and you had the judge who had to apply the law. You can already see a prefiguration of of separation of powers there if you want, but I'm not a specialist in classical Roman law. And why is it a modern answer to solve two major problems? The two major problems to which this is an answer is, first of all, that also the rulers must respect the law. So you need someone to watch the ruler, which evidently then creates the question, who watches the watchman? Which is a question we are discussing today. And secondly, the much more need for, at the same time, changing the law and maintaining social stability. Now, I've learned that mainly from Niklas Luhmann, but even if you have not read Luhmann, you can understand that. Separation of powers is an answer to the big problem. How can you at the same time change the law and apply the existing law? Well, by separating the functions, by separating legislator from judiciary. The legislator can change the law, but must respect the law as long as it's not changed, or at least the executive must respect the law as long as the legislator has not changed, and the judiciary will check the legislator, will control the legislator, and will apply the law as long as it has not changed. That is the traditional balance, modern answer to this problem and modern formulation of rule of law. And that rule of law is evidently, that the old Greeks knew it already, fundamental for individual freedom, because it's only possible to be free if citizens are only subject to general rules and not to the whims of the rulers. That the rulers must rule by general rules known in advance, that restrictions to liberty are determined in advance, what the Greeks called nomocracy, and there is no freedom without this type of rule of law. Rule of law, not of man. It is a limit to the power of kings and legislators, governments and bureaucrats, priests and judges. And the degree of rule of law is inversely proportional to the degree of discretion of those having power, whether legislators or ministers or judges or whatever. And there are the classical requirements of rule of law, which also show that why judges are not in a good position to make the law. Because the law must be in general terms, not individually decided, must be made public in advance, must be made in public deliberation, not in secret deliberation, and sufficiently clear and certain, and that's a problem evidently with legislators today as well as with anyone else. And in order to have a rule of law, you need evidently access to impartial judges who apply the law to individual cases. No one must be above the law, not the rulers, and the executive must always need a basis in the law to act. And I would add something which is problematic in my own country, but also especially in international courts, what the Germans call the gesetzliche Richter, which means that the judge who will decide the case is appointed before the case arises. You cannot determine which chamber of the court will discuss the case once the case is arisen. That is very strict in Germany, but for example, not at all respected in the European Court of Justice, by way of example, and not also, even in Belgium, we are somewhere in between. Now, when the rule of law is the opposite of arbitrariness, if you go back to all the classical authors for 2,500 years until some recent deviations, they will have this formal conception of the rule of law. For all of them, the rule of law was also an instrument for the common good, for the bonum commune, but precisely by not allowing a direct appeal to the good, but by obliging to follow the rule of law. Not the individual conception of what's best determines, but by general rules, by the rule of law, which means that the rule of law is also opposite to a rule of values, which is becoming dangerous because the European Court of Justice is applying a rule of values more than a rule of law today. Nevertheless, the Treaty of European Union still distinguishes in Article 2 human dignity, freedom, democracy, equality, the rule of law and human rights. They're different concepts. They're different concepts. And there's nothing to be gained by mixing them. And that's the problem, because they do conflict. The rule of law, democracy, and human rights are three different things. And we have to try to find a balance that they go together. But they do not always go together. They do conflict. Which means that sometimes the one is set aside in favor of the other. And evidently, there should be, or there can be, a symbiosis between the rule of law, democracy, and human rights, but that means that you have a certain form of democracy and that you have a certain idea about human rights. And if you develop the one of the three too much to the damage of the other, they come into conflict. If you have a wrong conception of democracy or a wrong conception of rule of law or an overreach of human rights, they will conflict. Well, by the way, human rights conflict between each other. There is not, it's not a single concept, evidently. So it does not help to mix them up. Yes. And especially when we consider constitutions or treaties as living documents, this is a power shift, because it means that the judges are making the law and will then decide how to balance these three things. But the rule of law limits democracy not by imposing new ideas about human rights, but by imposing, by controlling where the laws are made according to the existing rules, to the existing procedures, and these procedures are there precisely to temper the madness of the moment, to make sure that momentarily dominant ideas that in the long run should not survive are tempered a little bit, that that politicians cannot decide just on a single day to change everything. They need to take parliamentary procedures with lengthy debates and everything it includes. But what it stresses is that we still need what the Germans call demokratische Reversibilität, democratic reversibility. In a democracy, it is necessary that a democratically legitimated parliament at some point can change the rules. So I fundamentally disagree with the idea that judges can say that a change of constitution is unconstitutional. Because then you have a dictatorship of a Supreme Court. No, there's no one watching the watchman anymore at that point. Does this mean that judges should not sometimes make law? That's a violation of the rule of law, but sometimes it's necessary. The Nuremberg Tribunal applied retroactive laws. It's against all the rules of rule of law to retroactively, but it was right to do so. But also in the opposite sense, the executive sometimes should not apply judicial decisions or have means to set them aside. Every constitution in Western democracies knows that the government can individually grant mercy. That's against the rule of law, but it's necessary. So these three, we have really to distinguish these three concepts and know that sometimes the one will have priority of the other, but very prudent about the balance between these three. That was my main message for today.
Yeah, thank you, Matthias, for this very interesting point, because it will also gives power to our discussion. What does democracy means? What the independence means? What the rule of law is in relation to democracy? It is within the democracy. Could be a democracy without rule of law. So there are absolutely fundamental questions. I'm looking for. I will speak a little bit today about the Polish experience, and it is extremely important what Matthias said as a key point. We have to answer, even if the answer will be not the same. Okay, we are now having our last speaker, and now Mr. Demetriadis, you have a floor about the appointment of judiciary in Cyprus. The appointment is also in the one of the main battlefields as a guarantee for judicial independence. So the role of appointment. Thank you so much. You have a floor.
Thank you, Chair. I'll first thank the organizers for taking the risk to invite me, and then I'll declare my professional conflict in taking this speech, because when Nicolas was kind enough to invite me here, he knew exactly what he was doing, because I'm still doing a case which is on point. The Dean this morning mentioned it. So you will understand my conflict. I will not talk about the facts, but I will talk about the principles, because I think they are very important in the exercise we have today. So I think food for thought is what I will give you today, and I will concentrate on 2 points. One is promotion, and the other is appointment. The reason I've brought in promotion is because I couldn't really talk a lot about appointments, so I need to bring a second case in. The first case is before the European Court of Human Rights against Cyprus, and we are expecting judgment sometime in the new year. So I feel a bit more comfortable in talking about that, since it relates to the transitional period that was introduced as a result of the huge and very beneficial reforms that the judiciary put in place in 2023. So when they set up various issues like disciplinary boards or proper rules or procedures for promotion, the parliament gave them a transitional period, which according to one approach is that the various matters did not come into force until the bodies were set up, and people who were inevitably affected by these amendments did not have a chance to challenge their failure to be promoted. So this case before the European Court obviously went against the judge who didn't get the promotion, and that's why we are there. But it's extremely interesting to see how the judiciary on the one hand wanted to preserve their club by not having new things come in, which would have come anyway since Parliament had changed the law, but they at least got the transitional period, so they got 1 more year of extension in not applying what was actually a huge change in the system for the benefit of a lot of people, I think. Whether the court will come down on a right of fair trial or access to a remedy is, of course, open, and we can discuss it next year, perhaps, Nicolas, when we get the results on these cases. I'm mindful of the time, and I'm the last speaker, so I get hit mostly from the delay that everybody else has done. So I'm looking at the time very carefully, and I'm trying to limit it as much as I can. But I really have to say something about the case I'm not supposed to talk about. So what's the case about? It's the notion of a probation period. We are a common law country. We get our judges from the ranks of the lawyers. Colleagues of mine become judges. There is a system of selection. There is now a procedure for selection. The dean this morning talked about the body that makes the selection and alluded us to the point that it's not just the judiciary. There is the Attorney General, there is the chairman of the Bar Association, and there are 2 lawyers. Interestingly, they participate but have no vote. Now, is that good or bad? I'm not supposed to say, but you have to think about it. Now, if you have this body that does this promotion, this appointment, wouldn't you at least expect the same type of body to decide if you're fired? Would the decision for being fired or not renewed or your term being exhausted be the subject matter of the same body that appointed you? I leave that for you to decide as well. The problem of the probation period is that is a very good thing in the sense that you do not take a lawyer and put him on the other side of the court immediately, and you need some transition, you need some training. But we have no rules about that. Nowhere in the system is there a provision that judges are appointed for a probation period. And the way the case was argued is that there may not be specific provisions for a probation period, but since the candidates were told that there is a probation period, that gave the Supreme Council of Judicature a carte blanche to decide when this procedure is over, whether it can be extended, and what are the terms upon which it is terminated. Is it automatically? If I appoint you as judge with exactly the same terms as normal judges, but I say that I appoint you for a probation period of, for argument's sake, 12 months, what happens at the end of the 12 months? Are you automatically fired if there's no decision? Are you automatically appointed? Are you subject to a review by a body? Is the body that will carry out the review the same body that appointed you in the first place? Were people who participated in this body in the first place be allowed to decide at the end of the day as well? No answers. The answers will be given by two courts. The first answer will be perhaps be given by Luxembourg in case the referral under Article 267 makes it to Luxembourg, because there are issues of EU law that are coming up. This is a question of independence from the inside, not independence from the outside that we are normally concerned. We are concerned that a judge who was appointed on exactly the same terms as any other judge, which gives them security of tenure, which gives them the ability to stay until the end of their term, and that, of course, enhances independence, and that allows them to make these choices. These notions are enshrined in the European Union, and if you look at Article 19 of the Treaty of the European Union, the court has somehow transposed the obligations and requirements for appointment of EU judges into the national system. So you have to take that system as a benchmark to apply to your national judges, and that's interesting. And then if you take Article 47, the Charter from Fundamental Rights in the European Charter, then you get rights for fair trial and effective access and all the stuff you need to do. So the case will eventually be decided if there is a referral to the European Court, and that will be a question to be seen in case the court decides that EU law is relevant. And I've got to tell you, I have not been able to identify a single case in the European Union where transitional period was provided without the existence of a regulatory framework, especially in a common law country, the three of them that are left in the Union these days. So I think it's a very interesting question. To what extent can a concept of a probation period be imposed, managed, dealt with, applied in the absence of a specific regulatory framework? And is the consent asked for at the beginning of the process a carte blanche for this judge to be treated the way the person was treated? Now, let us say that this fails, and then the case will inevitably have to go to Strasbourg, in which case we will be dealing with EU issues, EU law issues, under the notion of fair trial. And the European Court of Human Rights has a very interesting case law lately from Ukraine, where a judge was actually taken off the bench, went to Strasbourg, and the Strasbourg court actually reappointed the person on the bench. Extremely revolutionary for Strasbourg in the operative part of a judgment to give you a provision whereby the judge is reappointed. This is the kind of framework within which one has to work. I'm looking at the time, I'm 9 minutes and 8 seconds. So I've got 45 seconds to finish. I am trying to do this as quickly as I can. I know some of the concepts, I've threw them out at you. I have not given you replies. It is on purpose. I did not want to give replies. I wanted to set the problem for you to discuss later on. And I will thank you, Chair, at 9 minutes and 33 seconds.
Thank you so much, because we have here also this interaction among courts in the process of appointment, which is another fascinating topic also in relation to my country, this interplay among the international courts and judicial system of a country. Of course, now we are in terrible delay, but still I think because the delay is not on our side in certain sense, so we were on time. What I would like to suggest, we have probably to have 10 minutes for discussion, or what is your? Okay. Yeah, you know, okay, I'm on your side. 5 to 7 minutes for discussion. So I will collect questions, and then I will ask the panelists for answers. So please, yeah. Mr. Reichmann.
Very interesting. Thank you for all. I do have a question for each, but for the sake of time, maybe I will present them later on over lunch. But two questions. One about the principle of, to Matthias, about the principle of irreversibility, which is very interesting, precisely because, and you haven't talked about the other side, the illiberal side precisely would like to capture. So if you look at the idea of unconstitutional constitutional amendment, and you see how it is applied, or how it should be applied correctly, it is precisely to avoid entrenching stuff that shouldn't be entrenched. So it's true that when judges do that, they maybe become, they're subject to the criticism you raise. But if they don't do it, the principle of irreversibility equally, maybe if not more, suffers. So maybe you should also address the other part of the problem. With respect to the idea of secret justice, maybe you have just to give you a chance to speak, if there is one thing that you think that the British system should improve in, what would that be?
Thank you. Another questions from the floor? If I don't see only one issue also related to Matthias, do you think that the concept of the Court of Justice of the European Union, with the preliminary ruling and so this perception of interpreting the law somehow not related to facts, even the facts must be given, violates this your concept about the separation of power? But it was just a question, whether there are other questions. If we do not have them, please feel free to answer. So Matthias, you have been called.
But first, I agree with you. I do agree that politicians try to entrench too much in constitutions. But it's to make it judge-proof. So it's because there's this power struggle on both sides.
So what do you do?
And we have to go back to sovereignty of parliament without entrenching. We should have much less in our constitutions, much less. And on the second point,
I would like to add one more question to the panel, but to Matthias. Is the court the last line of defense of democracy, which gives it responsibility to act differently in times of crisis? If you say no to this question, you need to be maybe longer for giving an answer. But I think the most important point from recent events, if the court does not understand that it is the final line, the last line of defense, then we see very serious problems in many societies. So the question is, what is the role of the judge in crisis times, when the judge, can he say, well, it's not my job, you take care, you, the parliament, you, the executive, you want to destroy the democracy, it's your problem? Or he said, no, I am, here stops the buck, as they say in America. This is the last point. If I don't save it, and then you have to dialogue with the public. The question is, do you have public support? Now, one more sentence. In Israel, the courts have, or the Supreme Court has, 40% public confidence, 40% in the rating. It used to have 80%. So its own record decreased. But the other branches, the parliament has less than 20. The government has much less than the parliament. So they claim that they can represent the public. That's the issue.
Okay, so we have to answer the questions. But
I also have one point, if
Yeah.
possible, for Achilleas. I just wanted to add if you expected more support by some associations in handling this case, for example, the Bar Association or any other international associations, or
You have the right to remain silent.
I'll take the fifth.
okay, so now Matthias, please continue, and then Professor de Vitialis, Mr. de Vitialis.
There is nothing wrong with preliminary procedures as such. They're 2,000 years old. There's nothing wrong with the preliminary procedure where you refer the question of law to a higher court. There is something wrong in the way it is sometimes used. When it is a power grab, shifting powers from the member states to the Union, and especially to the Court of the Union, in a way that even the Parliament of the Union cannot change it anymore. Then there is a serious problem. Then you're acting ultra vires, and there is no one who is controlling the ECG today. They can decide anything they want, and they sometimes do. This is a serious problem of watching the watchmen there. Are the courts the last resort? Well, to some extent they should be, but anyway, you are already in a very poor state of democracy if the courts are the last resort. And if you are in such a bad shape already as a democracy, the courts as last resort will not solve it. So you need a lively democracy. You need a thriving democracy. And if you don't have that, it's only a second-hand remedy that you have.
Professor Zelik, and
The short answer is a court that will always sit in private will never command public confidence and will never adhere to the principles of an independent judiciary. When the Investigatory Powers Tribunal was established in 2000, the government made the procedural rules, one of which said the tribunal may never sit in public. In 2003, the president and the vice president reached a decision saying that rule was ultra vires, would not be applied, and the tribunal will sit in public whenever it can, which is what it has done for the last 20 plus years. Inevitably, a lot of material has to be examined in private, but even then you can devise mechanisms to ensure that the interests of the claimant, the plaintiff, are represented, and as much as possible is put into the public domain, into open court, with open judgments and open reasons. And unless you do that, you will not succeed in establishing a tribunal that attracts public confidence.
Mr. Dimitriadis.
Yes. Well, thank you. I'll be very brief to what Nicolas has asked. A very, very good question, very hard question, but I will not fall for it. I promised myself I would not make any comments on the case because that's what we try to do. But I will say something in relation to the procedure of the case, which I found extremely interesting and I think very beneficial for the discussion that has taken place. It is the second time, and this time it really blew out of proportion, that pleadings in the case were actually published. We started off by publishing the decision about the judge, which was very extensive, which would otherwise not have been a public document. So that went on to the Supreme Court's webpage. And then after that, to everyone's surprise, all the applications, all the written addresses, and the whole matter went public. And I think that is perhaps what this case will be remembered for, by opening up the procedure and allowing people to actually read what is going on and not simply rely on the press. So I hope that part reply is good, and I'll come next year to talk about the case. So thank you very much.
Thank you very much. Thank you very much to all speakers for this extremely fascinating presentations. We have probably, it will be a matter for a long discussion which we have to continue in the coffee break and other breaks and dinner. Thank you so much for participation, and see for further for next panels. Thank you so much.